apologize for being late, but there's good reason for that. Last Tuesday night, I'm sorry, but let me back up. Monday of this week, I'm involved in a case where I represent an orthopedic surgery center, and we filed a motion for temporary injunction and complaint for injunctive relief and violations of Florida's unfair deceptive trade practices. And the injunction was granted last month, and they filed a motion to dissolve the injunction on Monday of this week. And under the rule requires that the judge set the hearing within 5 days. So on Tuesday, Judge St. Arnold set the hearing for this morning. So it was essentially like getting ready for a trial in 48 hours and getting all our witnesses and evidence together. But to that extent, I apologize, but I'm here, I made it. We went over 45 minutes of our hearing, so I'm just happy I'm here. I want to thank Pete Dragos for inviting me today, and see a few familiar faces in the crowd. It looks like the Clearwater Board trustees maybe stacked the house for making me feel warm and welcome here today. Thanks, Karen, for being here. Thanks. Thank you all for showing up. We're going to certainly try to touch upon some things that hopefully you don't know. And if you do know them, then maybe that it just gets reinforced, and it just goes to show how good these lunch and learns really are for lawyers in the community. I want to make sure I don't miss anything here in introductions. How many folks do creditors work solely creditors work? Anybody? No. All right. How many people do business litigation, personal injury litigation, civil litigation? All right. A lot of folks. All right, and the rest of you have a litigation practice, I presume, of some sort, because you're here, or at least want to learn about it. I have another seminar that I present that I do for Stetson College of Law every year in their, they call it a boot camp, whatever it is, and it's dealing with collection of attorney's fees and getting your fees from your client. Okay, so that's a really good seminar. As a result of my lack of full preparation, if anybody knows me, knows how over the top I am when it comes to prepare. I had 33 pages of color exhibits today for Judge St. Arnold. I made my whole staff work last night till 10 o'clock. I was there at 5 o'clock this morning. We were ready for trial this morning. So I apologize that this took a little bit of a back end, but I want to tell you this. If you get me your name and address and your email, or take my card and email me, I have a wealth of information that I put together that I haven't had time to copy for you, you'll learn about today if you want to take advantage of that resource from my personal archive. Just a few comments about judgment collection before we get into the slides. One, I think it's of paramount importance for lawyers to, and again, I'm speaking from the perspective today that you're not going to be collecting from an insurance company. Certainly it makes a much bigger difference, I think, from the perspective of collectability when you have a pocket out there that's for certain or sure. And even if you get a judgment, the likelihood that they'll be able to post a judgment bond and you take it up on appeal, at least the money's going to be there. I'm talking to you people out there that are nuts and bolts, commercial litigators, civil litigators, where there may not be an insurance policy to get. So you're going to have to go look for assets. All right, and try to get that judgment paid. Because we all know, and I'll get into this in a little while, that judgment, that piece of paper that the judgment's on, is worth the piece of paper it's written on. Some people might call that soft paper. You know what soft paper is? Yeah, you can do something with it, soft paper. Because it's not going to get you anything unless you collect on it. So I want to make a few comments that I think it behooves us as lawyers to discuss with our clients. First, I think before we take a case, the client and you need to have a talk about whether there's assets to get. There may be great liability, but if there's not going to be assets to get, your client's going to suffer a Pyrrhic victory at the end here. They're going to have burned the barn down. You say charge the hill, and then they're not happy because they get their judgment, and then you tell them, oh, by the way, and they come to you and say, hey, Pete, when are they going to pay us? And the answer is, well, that's a whole different conversation we need to have. What? Have that conversation up front, maybe do some type of background pre-suit investigation, and find out if the defendant is going to have anything to get. A lot of smart people out there, and I'm suing some of them, that have a lot of assets, but whether you can get them or not is another story. I've got a $35 million lawsuit right now, one of the biggest mobile home park ownerships in the state. We know that the defendants group, primarily one principal, has money, but is it going to be, are we going to be able to get it? It's titled in him and his wife's name. He's got different corporations. He's got retirement plans, things that are exempt from seizure. He's got homestead. I mean, so you want to look at whether, in fact, there's going to be something to get. If the client says, listen, it's about my day in court, I say, listen, I love litigating. It's how I make a living. Principle to me matters. Principle generally matters, though, in terms of what's in your bank account, not for extracting a pound of flesh. If you want your pound of flesh, this may not make you feel really good at the end of this. Because you're going to get my bill after the first month and you're going to wonder, should I really be doing this if I'm not going to collect anything? If there's endless streams of income coming your way, send that client to me. I would love to have that client as my client who just doesn't care other than principle. But at some point, you want to make sure that when you meet with that client about your bill and whether you're going to collect anything, we've had this conversation before, Mr. Smith, you know, it's going to take money to fund this litigation. And I always say, getting the judgment is half the battle. Collecting on the judgment, sometimes and more frequently, costs more money to chase the money. Because you don't generally see folks that have a judgment placed against them, then turn around the next day and pay the judgment. All right, it takes time, it takes perseverance. I'm also not going to talk to you today, which if you have any question about, is litigation with the federal government. I know some of you folks litigate against the federal government. It's a very different animal. They have weapons at their disposal that we as private litigants do not have. I was in Boston last week. I'm litigating against the Securities Exchange Commission. I have a big parallel case where they've indicted my client for some other stuff, but he's facing SEC charges for being a promoter of unregistered securities fraud. What happens to, what does the SEC and a government entity, the FTC, the DOJ have at their disposal that we generally don't have are these pre-judgment injunctions, Mariva injunctions sometimes they're called, so that assets are frozen, locked down, ex parte by a judge before there's even a complaint served. How nice would that be as a private party plaintiff to be in that situation? But if you're interested in that stuff, let me know. I have a lot of information, a wealth of knowledge on that. There are opportunities for lawyers to take those cases and create carve-outs for attorney's fees, carve-outs for living expenses. So that's another topic for another day. Scope of the representation. Again, you want to talk to your client about what you're going to do. Some clients don't understand what scope of representation means, and that can come back to bite you. Because if let's say you get a judgment, and then you record the judgment, and the client says, okay, I got my judgment, you send a letter of termination, the next thing you know, the client's wondering, what are you doing to get my money? That's fertile ground for malpractice. I think you've got to be clear in your scope, if not in your termination letter, of what you're doing and what you're ending your representation and what the client needs to then do. Because a lot of clients don't know the judgment that you got then needs to be recorded. And I'm getting a little out of line, but I know we're limited on time. So if I speak out of line, it's stuff I'm going to be talking about. I want these to be thoughts in advance. You got to record the judgment. You record the judgment with the Division of Corporations. You get a judgment lien certificate filed, and then you re-record the certified judgment in a county in which the defendant may hold property. Which brings me back to the asset search. You can do these asset searches on LexisNexis, or you can pay a third party, just to get an idea of what assets the defendant might have. You might do a UCC1 lien search to see if there's financing statements out there on the defendant's property. You know, we generally don't get financial disclosures pre-judgment, which would be nice, but we don't get that. So make sure your client knows that the judgment that you finally got, you record it. It's good for 10 years. and then you got to re-record it for up to 20. But if they don't know that, and they don't know what you're doing, or if there's potentially third-party relief defendants out there that should have been pursued, you really is fertile ground for malpractice. Be aware that once you get the judgment, your work's not over, and make sure unless you make sure you tell your client that the work is over, that they should contact another lawyer that does collections or decide with you what type of scope and further representation you're going to engage in. Okay. If you hear nothing else from me today, yes, sir?
You said it's good for 20 years after you re-record it. Is that an additional 10?
10 and 10. 10 and 10. Thank you. Good question. Sorry for the miscommunication. If you don't learn anything else from me today, also just be aware. Somewhere down the road, you're going to remember like 3 things I said today. The FDCPA. As a creditor's lawyer, you've got to be aware of the Fair Debt Collection Practice Act. Whether it applies to you or not, you need to know that. Okay? Because if it does eventually attach to you, there's going to be liability. And lawyers are on the hook. Okay? It used to just apply to debt collectors. It now applies to lawyers that are regularly engaged in the practice of debt collection. And what does that mean? You got to read the case law. Because it could be 1% of your practice, but if it's done on a regular basis, you may be deemed to fall within the FDCPA. It also applies to personal debt, not commercial debt. Okay? All right. Let's see what we got here. Prejudgment settlement. The settlement before judgment. What do I want to talk about here? All right, I learned this the hard way, and of course, I think that's a good way in life to learn. And as lawyers, as good lawyers, we learn vicariously through the acts of others. Hopefully we learn and it doesn't bite us too bad. But here's all I wanted to say here. Let's say we got a lawsuit, and you've put the pressure on the defendants, and now you've agreed to get a settlement agreement drafted. You want to make sure that your settlement agreement, and I'm talking about state court right now, in your state court settlement claim, you want to make sure there's a clause reserving jurisdiction with the circuit court to enforce that settlement agreement. So you don't have to start a new case, okay? So you don't have to reserve people, okay? You generally want to make sure that there's adequate waivers in that settlement agreement for purposes of notice. But just make sure in your settlement agreement in state court, reserve the right for the court to retain jurisdiction. Now, federal court's a little different. Federal court, you still want to have a clause that says that the federal court shall reserve jurisdiction. Well, that's great. Between me and Peter Tragos, we settle a case, for instance, and we agree that that judge is going to reserve jurisdiction. You know what? That judge doesn't care what Peter Tragos and I agreed to, okay? What you're going to have to do is that you're going to have to put the settlement agreement before the federal court judge. You're going to have to send it to the federal court judge, have an order entered that says that the court hereby agrees to retain jurisdiction to enforce the terms of the settlement agreement. Otherwise, that agreement that he and I had, his clients had, my clients had, and we agreed to bring it back before the court in case his clients don't pay my clients. Federal court judges generally, in my experience, will do this to for that suit. Poof! They will punt it back to you. And when you do a motion to reopen or a motion to enforce settlement agreement without an order previously entered, with them reviewing that settlement agreement and agreeing to retain jurisdiction, they will punt that case back to you and they will say motion denied, end of story. And then what do? What do you mean motion denied? I got to get my money out of the defendant. Well, not all hope is lost. You have to file a state court action for breach of contract. All right? So if the federal court judge punch your settlement agreement back, don't despair. Don't think you committed malpractice. You got to talk to your client and say, our remedy is to file a breach of contract claim in state court now. Because remember, federal courts are courts of limited jurisdiction. They're looking at this as a plain vanilla breach of contract claim. I may have brought a claim for securities fraud. I may have brought a claim for all kinds of federal question issues or based on federal statute, but now it's just a plain vanilla settlement agreement. Yes, sir.
What's the benefit of doing that as opposed to, like in some of our settlement statements or our general releases that we'll have people sign, it'll say, if you don't pay in X amount of days, you breach the contract, there's liquidated damages, blah, 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 blah. What's the benefit in having it be, like what you're saying, keep it in the jurisdiction of the court that it's in and just going to get the court to do it?
I like to have it be retained in state and federal court, because federal court tends to be more intimidating for defendants. Certainly the option is, in the event of a default, here's what the defendant agrees to pay, and in the event they don't, you're still left with reopening your state court case, which I never had a problem with. It's federal court judges tend to have this, I don't want to deal with it anymore. There's not a federal question. It's not a complaint based upon a federal statute, so I'm not going to deal with it unless I previously agreed to deal with it. But my experience is in federal court, it gets the attention of defendants real quick, especially under, I think, Rule 45, the subpoena rule allows the court to subpoena the witness to appear before it to disclose his assets. Well, that ain't intimidating, right? I mean, so not only do I have the right to do the fact information sheet in state court and issue subpoenas, but the federal court judge has the right to call you in as a witness to disclose your assets. And you can invoke the powers of the court. So that's a benefit for federal court. And then, of course, U.S. Marshal Service is at your disposal to a certain extent. You know, U.S. Marshal Service comes knocking on your door looking for assets. People get really generally motivated to settle the case. Okay. If you have this scenario in federal court, you might want to also think about in your settlement agreement to have a waiver of service. Just simple notice of default is all that you're going to be required to do. Otherwise, and this happened in a case of mine, I had defendants all over the country. Wyoming, Texas, California. And it took us, I think my client spent about $4 grand in trying to perfect service on these people. That's a lot of money. Now we got to come back to Florida, refile suit for breach of contract. We got to reserve all these people again. Get in your settlement agreement that the defendants hereby waive formal service of process, and they simply will either accept service through their attorney or by U.S. mail. All right? Tidbit of information will save you a lot of pain and aggravation. The judgment. Let me just make a few comments about the judgment. As I said, once you get a judgment, usually in most states, and I know we're not concerned about most states, we're concerned about Florida, you got to wait 10 days before you do anything on it, under the rules. There's 30 days in which the defendant can appeal, unless it's based on fraud, which is Rule 1.540. Can't file a challenge to a judgment, can't move to vacate it after that period of time unless based upon fraud. But it has to be done within that 1 year. All right, we talked about the judgment, getting the judgment, submitting the judgment lien certificate, re-recording the judgment in the county in which you believe the defendant to have property. And I believe the statute is 55.07, which says you've got the judgment for 10 years. Debt collector or not. All right, this again is something that you want to look at, which is governed by 15 U.S.C. 1692, the Fair Debt Collection Practices Act, and whether an attorney is a debt collector, and the statute defines debt collector, but certainly encompasses lawyers. I'm not going to read what we've prepared for you, but understand, I have this, I'll send it to you. It's a good snippet of information on whether, in fact, your practice might encompass the FDCPA. The other issue here is, well, let me move on to the next slide. Discovery and aid of execution. what do we do to find out whether folks have anything to satisfy the judgment? Once we get a judgment in Florida, we generally attach the fact information sheet, which is, in my opinion, a paltry, like 4 or 5 pages. And I say paltry in comparison to what? In comparison to some of the financial disclosure forms required by federal agencies. So I don't like using the fact information sheet much anymore. I put together my own form or include that and then send out my own interrogatories based upon the federal disclosure statement. And I have that. So if you're interested, I'll be giving you a financial disclosure statement for individuals that the Federal Trade Commission uses. And I'll be giving you a financial disclosure statement that the Federal Trade Commission uses for individuals and for corporations. So it's very, very extensive. It makes people really think what they need to disclose. I got a judgment against the guy in Jacksonville. I think we're on our 3rd or 4th amended fact information sheet. Oh, I forgot about that. Oh, I forgot about that. I've had him held in contempt for like 4 times. I've had him put in jail twice. He just doesn't want to give me anything. These federal forms are really good. So, discovery and aid of execution. What do we want to get? We want to get the fact information sheet. And my suggestion is when you get that judgment, you send it to the defendant and have him fill out that fact information sheet within 45 days. Why not propound some discovery on him right then and there? Send him some requests to produce documents and some interrogatories. All right, and those questions, again, I will send those to you of what to ask for. And I've got a really good handout. I bought it. It's for purposes of asset depositions. Again, you're here today, let me know, I'll send that to you. Man, it goes through everything. I mean, it virtually takes you in a paper trail through the person's life. I'm talking jewelry and baseball cards and guns and you name it, stocks and bonds and tangibles and arcade equipment, whatever it is, they've got to disclose it for you, and you can do it with interrogatories using these forms. Request to produce are nice. Again, I've got a sample for you, but let me see your tax returns, let me see your pay stubs, let me see your mortgages, let me see your deeds, let me see your car payments, let me see your life insurance, let me see your homeowner's insurance. People don't like to tell about the what I call the assets that they can move around. Watches, I got a couple nice watches, but if you're going to ask me if you can have them, I'll probably tell you no, and I'll tell you I don't have them anymore. But if they're declaring them on their homeowner's insurance, they probably still have it. Well, Judge, why are they still declaring 4 Breitlings, a Rolex, pearl necklace, diamond earrings? Why are they still declaring all this stuff? They're paying for it on their homeowner's insurance, but they're telling me they don't have it. So, and then of course, that might move into what's called a fraudulent transfer issue when you give your watch to your brother, your cousin, your mother, your gun collection away, and I've seen that happen before. And then I put the red dot on another third party who doesn't want to be involved in the case because of their friend's gratuitous gift of property transfer. They now become my target. And generally people don't want to be brought into court if they can help it. So, fact information sheet, accounting disclosures, asset depositions, interrogatories, request to produce. Contempt proceedings. I think this is funny. He's got mistletoe over his butt. All right. Contempt proceedings. 2 different types of contempt proceedings available. One is criminal, one is civil. I've been involved in both, not personally, but I've been involved in both, and I will tell you, I have been involved in civil contempt proceedings, and I thought I was in a criminal contempt proceeding. Because you can go to jail, or your client can go to jail. I guess you could too. In civil contempt. In fact, I've had, as I indicated, someone, and Laura knows this, taken into custody twice. Once while he was visiting Pinellas County, and once while he was attending a deposition in another lawsuit he was in. He's a businessman from Jacksonville. I found out where he was. I had Orange County Sheriff's Office go to the deposition, take him into custody based upon a writ of bodily attachment because of his contempt. So contempt can be civil or criminal. What is the difference? Criminal contempt is meant to punish. Civil contempt is meant to vindicate or to make the person, the contemptor, do what he or she was supposed to do. They say that the contemptor in civil proceedings holds the keys to the jailhouse door. That means that they have to have the ability to purge the contempt, i.e., judge, they didn't fill out the fact information sheet. I've been asking them, they've been court ordered to do it, they still haven't done it. I want a finding of contempt. Judge finds them in contempt, finds that they've got, you might ask, give them 30 days or 15 days to comply. What I do is I ask for the court to impose a fine for every day thereafter. Let's say it's 15 days. So Judge, I want you to also impose a fine of, say, $500 a day for every day that they don't produce that fact information sheet to me for up to 30 days. And I just sit back and wait. Day 15 comes, I get nothing. I wait another 30 days at $500 a day. Then I move for a writ of bodily attachment, and the writ of bodily attachment will say that in order to purge, the defendant has to give a fact information sheet and 15 grand to plaintiff's counsel. Because $500 a day times 3 days is 15 grand. Okay? I've had that happen. So that for them to get out of Pinellas County Jail, somebody in their family's got to send me money for 15 grand and do the fact information.
Robert, let's presume for a second the defendant that's been attached and has then been arrested based on that order doesn't have the 15 grand. How long does he stay in custody?
In my experience, what happens is the order says that, great question, the order says that the defendant can be held for up to 48 hours before seeing a judicial officer, but generally what happens is the advisory judge will refer him back to the judge that signed the order, and then the judge that signed the order will call an immediate hearing, almost like a sua sponte writ of habeas corpus. They bring the defendant in, and then they find out, you know, do you have the ability to pay? I try to get the order fashioned before the writ is entered, that the court is hereby making a finding that the defendant has the ability to pay. That solves that problem. The problem is if he doesn't have that ability to pay, then you go, well, guess what you're going to have to do? Eckard doesn't know whether you got the ability to pay because you haven't given him the fact information sheet.
Right.
How does he know you can't pay if you won't disclose your assets? The presumption is you can pay it. That's what my argument is. Give me the documents, give me your assets, and then let's see. Get testimony in here, get your wife in here, get your aunt and uncle, get your friends. I want to know you don't have the money to pay.
Or what happens if he says, you know, forget it, I'm not telling him nothing. How long can the judge hold him?
In state court, I believe it's 180 days.
Okay.
Federal court is different. Federal court, there's a couple rules in federal court. In federal court, if you're held in civil contempt, if you're held in civil contempt, say in a criminal proceeding because you're not willing to testify, like in a grand jury proceeding, you can be held for the length that the grand jury's been impaneled.
Oh my God.
Or I've seen cases that have been upheld that said the contempt can last up to, I'm going to sentence you to contempt 4 years. Civil contempt. Or the judge immediately says, I'm going to remand you for 1 day. And I'm okay with this generally. Teach the guy a lesson or the gal a lesson. I'm going to immediately remand you for 1 day. I'm going to let you out. You got 15 days to comply. Day 15, there's a $500 fine up to 30 days. And if Eckard comes back, he's going to ask for a writ of bodily attachment. It's going to be considered. So I've got a case for you that that's still good law, and it's here from our Sixth Circuit from one of our judges. It's some of you may know this. It's channel components versus America 2 Electronics. It's Judge Shame's case. Anybody know this case? The Second District Court of Appeal. It's in 915 Southern 2nd, 1278, 2005 Second DCA. In this case, Judge Shame issued a fine of $2,500 a day for discovery violations for up to 30 days. $2,500 a day, and it was upheld on appeal. So when I ask for $500, I say, Judge, I'm being easy. You know, Judge Shames says you can find up to $2,500 a day. So that's a pretty good case to cite.
What's the citation again, please?
915 Southern 2nd, 1278. Channel. Yes, sir.
I see you have a slide on it, and I'd like to hear about it, and I don't know how much time we have, but how do you get paid on this? If it's a contingency, if we're gonna do it for one of our clients, and we have a contingent fee agreement, and we're already getting a third or 40% of the judgment, and then we're gonna have to do, and we've already worked to get that judgment, so now, is there any contingency on however much we collect from the judgment? Do we have to, I mean, most of them can't pay us hourly anyways, if it's a contingency fee case.
Yeah,
How do we pass it off to you? Yeah. You deal with it.
Or what's it cost? That's another question. Or what's it cost to have somebody else deal with it?
That's why I keep, that's my Stetson presentation. That's why I keep meticulous records of my time and billing. Let me see if I can answer your question. How do you get paid? How do you get paid on a contingency case where they're not going to pay you attorney's fees? Are you saying for attorney's fees?
No, the judgment.
How do you get paid?
No, like on top of, okay, let's say it's a $100,000 judgment to make it easy. We get 40%, it's in litigation, we get 40,000 of that 100,000. Is that what we're capped at? No matter how, if it's 5 years to collect on that judgment that we're nonstop working, filing these interrogatories that they have to answer, getting a writ of bodily attachment attached, doing all that.
I think you'd have to go back to your retainer agreement and say, what is the scope of my representation? But if my scope of my representation is this portion of the case, but it involves collateral or ancillary proceedings, then I think we got to talk about another form of compensation. The problem is if your folks don't have any money to chase money, you know, you're kind of going down this rabbit hole on your own. And I'll tell you, I call it satellite litigation. I took a very hefty fee about a month ago for a criminal case in Boston. I also took a smaller fee to be used to address the contempt proceedings in the Security Exchange Commission case. So I got the DOJ case and I got the SEC case. Got a little pot of money over here for the SEC case. I figured I'll go handle the contempt because this guy's lawyer previously didn't know what he was doing. He screwed it up and he's got a contempt proceeding. I need to get this guy out of trouble because the federal court judge is going to hold him in contempt. What has happened since then has been, I call satellite litigation. I have been to Boston a couple times. We have incurred at least 2 or 3 lawyers working on this case for days, straight days, preparing for hearing. The judge says, I'll see you back in 2 weeks. I want briefing on this. I want to see you back now. I'm going to take it under advisement. I want a briefing on this. Next thing I know, I got 80, 90 grand in fees on a case I took a $25,000 retainer on, and I'm like, whoa, you know, so I got to shift some of the money earned in the criminal case and say, we need to rediscuss this proceeding. So, what do you do? Boy, that's why I don't do contingency work on stuff that's not, I don't do any contingency work, but, you know, I guess the benefit reward is.
Let me change the question a little bit.
Okay.
Let's presume we do take a personal injury case and we get a judgment on it, and it's a good case, but we don't do collections work, and we don't want to learn how to do collections work. We're going to send it to you. How then are you going to bill our client, recognizing he's got a personal injury judgment, X dollars, knowing that we have 40% of that because it's our contingent fee or whatever we collect, I'm guessing, is going to be 40%, and then you're going to have to build on top of that.
Yeah.
How are we going to structure that?
I think the guys I know that do that will ask for 40% of the entire amount. Mm-hmm. So you guys are getting 40. This guy's going to get 40. The plaintiff's probably not going to get a whole lot of money. Some collection attorneys that work on a contingency will cap their amount to 20%. To make it, and some people say it's inherently unfair for the plaintiff to get less than the lawyers. And I respect that, as long as I know going in. But I don't want to be knee deep in or down this rabbit hole and come out of this thing with 10 grand when I've spent 900 hours chasing butterflies.
Exactly.
So I think it depends on the month. 100 grand's tough. 10 million.
I know if it's $1 million,
yeah,
it's a different discussion.
It may be worth it. It may be worth it. I'd do a serious asset background investigation. I would use some proprietary tools, maybe a private investigator, to see if there's anything to be attached. It depends upon, and I know we're running out of time, but it depends upon the location of the asset too. I mean, certain states don't give the protections like Florida does. I sued a guy from Tennessee. Some of the defendants were here in Florida. One was in Tennessee. As soon as I was going to attach his house, he paid my client 60 grand. It was a $180,000 judgment, paid my client 60, said, let me out, there's 5 other defendants, let me out. Because I was going to get his house. Tennessee, there's no homestead protection. So it depends upon the state and the jurisdiction you're in. Okay. Carpe diem, seize the day. What type of remedies might you have? Pre-suit, both pre-suit and post-suit. Pre-suit is, I love writs of replevin. I've exercised them many times. They certainly are a wake-up call for the defendant. I'm getting ready to do one now. In a way, they're like, the FTC or the SEC or the DOJ or somebody comes in, they get the ex parte writ, they seize all the assets, and then they serve you with a complaint. They got all your clients' assets and bank accounts and everything. Writs of replevin are a little like that. I'm getting ready to do one now on a tanning salon in Citrus County, where the defendant bought my client's salon. My client held a note for about $50,000, gave her a UCC1 lien, and hasn't paid, defaulted. We've accelerated the note, and now we're going to, I'm going to file a suit for breach of contract, breach of promissory note, and do a ex parte writ of replevin and go in and seize the property. 3 months ago, I did a nightclub in Newport Richey, and boy, was the defendant pissed. He shows up, the cops are there, you can't take this, Sheriff's got a court order, a list of all the assets, and my guy's there with a locksmith, because we get a break order. That's really important. When you do a writ of replevin, you gotta have a break order. And that's gotta be part of your writ. That means the sheriff can break the door down and get the equipment. No break order, you're not getting in unless the defendant lets you in, and that ain't gonna happen. All right, voluntarily. So you get the break order, you go in, locksmith generally comes in, pops the lock, that's your break. You get in there, sheriff stands there with the order, everything's got to be identified in your writ of replevin. I'm talking down to the pencil. The sheriff is looking at a list, and unless that list contains everything that your client wants, your client goes, oh, you know what, Rob? That flag is mine too. And the sheriff goes, on the list? Nope, not unless you don't get it. Extension cord, on list? Nope, don't get it. You got to list everything, because the sheriff is just doing what they need to do to get in and get out of there. But those writ of replevins, they often result in a resolution when the client knows, or the defendant knows, you're coming to get his stuff. What do I need to do to settle this, Mr. Eckard? What do I need to do? Well, you can start by making a payment to my client. Okay, let's get some money flowing in. So generally, defendants don't want the stuff; they want the money. That seized the day. Post-judgment, you got writs of you levy on personal property, have a marshal or sheriff sale. There's a sale coming up here November 4th down at the courthouse. A client of mine who was a currency dealer, he was a really shady cat. He dealt in foreign currency and gold and silver and valuables, and what he'd do is he'd borrow money from people, and he'd say, well, I'm going to secure it against this bunch of assets. By the way, he gave me a $500 bill, and it's like worth $3 grand. It's hanging on my wall. It's pretty cool. So I know he's got some valuable stuff. But he told people, here, you invest with me, and I'll secure it against this corpus of assets. We did that like to 10 people for the same corpus. Yeah, you can't do that. So what happened? Got a judgment against them. Finally, U.S. Marshal Service came in, unbeknownst to anybody, and they seized all his stuff. And it's going to be for sale November 4th down at the courthouse. So if you want any cool currency and gold bars, it's going to be down there. They don't sell it individually. You got to buy it by the lot. Let's see. Fraudulent transfers and proceeding supplementary. Proceeding supplementary, you really need to have evidence obtained post-discovery or discovery date of execution. You really need to have this information that would lead you to believe that assets are transferred to a third party without consideration. More like a fraudulent transfer. So to begin proceeding supplementary, which is a whole separate lawsuit, but if there's a lawsuit against somebody for the recovery of property that you learned was transferred during the underlying litigation, and I think the key terms are to hinder, delay, or obstruct the creditor, then that's what a fraudulent transfer is, and then you could begin 726, I think chapter 726, fraudulent transfer or proceeding supplementary against them. Attorney's fees on the judgment. I like this one. A lawyer unpaid is justice denied, right? Man, I tell you what, I am the biggest advocate for lawyers. When people come in and see me and they're changing lawyers, I know this is a side note, but I say, did you pay your lawyer? Did you pay the guy or gal before me? Because if they didn't, I'm not really interested in the case. Go get square with them, because if they didn't get square with them, they're probably going to do the same thing to me. Fortunately, I've been part of my career where now I can kind of pick and choose, but you know, that whole gut reaction, if they screwed someone else, they're probably going to screw you. You guys probably don't have clients like that. No, I do. Or potential clients. Show me the money. Rule 1.525 says you got to file a motion within 30 days of getting the judgment for your fees. Don't file it, you don't get your fees. Another reason why you want to keep, and I don't know, do you guys that do crime and PI, you keep track of your time?
On certain cases, not
Yeah,
every case.
Not every case. And that's kind of the, practice and procedure. I'm just so used to keeping track of all my time, whether it's criminal or commercial litigation, because I bill hourly on both, criminal and civil. Sometimes just a flat fee. But I tell people, here's, when I teach the Stetson course, I say, I keep track of my hours in detail for 3 reasons. One, so I can send my client a bill, and they see what I've done, and what every lawyer in my firm has done, and how much time they've spent doing it, and what it is they did. So I've got the person, the time, the narrative. 1. 2, second reason I do it is so maybe my client's going to have an opportunity to get their fees back, and the judge is going to review it. I was put on the witness stand 3 months ago with Judge Jenkins in a case where I got the court to invoke its inherent power doctrine, the inherent powers doctrine, to award my firm fees for a frivolous wage claim that the plaintiff's firm filed against my client, who was a restaurant. My client paid the claim, DOL had closed it out, they filed suit anyway, after notice was given to them. So we filed motions for sanctions against the defendant and his lawyer. And the Judge Jenkins considered the motion, not under a federal statute, not under, the FLSA or anything like that, which you don't get, only defendants get fees, but under the inherent powers of the court to regulate their dockets and frivolous pleadings. Judge awarded fees, but I had to take the witness stand. And what did I do? We introduced my affidavit and my billing records. She found that my fee was reasonable, at $3.75 an hour, and the time spent was reasonable. Of course, then you have an expert come in, a guy like Charlie Marcos or Chuck Hoover, somebody that does this kind of stuff, and they file an affidavit of reasonableness, and you get your fees. So, point 2, fees for your billing records for clients, your billing records to get attorney's fees awarded by the court, and your third is, I don't really ever want a problem with the Florida bar. So there's this rule, there's this rule, even in criminal cases where, they shouldn't really question the reasonableness of your fee, but they can. But I've yet to see that happen, but I think they still have the right to do it. Benny Lazare is a lawyer in Tampa, used to be, he says, what's a reasonable fee? He says, whatever anybody will pay me, and that's my opinion. If I want to hire Pete Tragos or Pete Sardis, and it's a criminal case, and I know he's great, and I want to pay him, $200,000, I'm going to be a priority in that guy's life, right? Somebody else might charge $50,000. Why is that fee unreasonable? I guess it's not, but the bar could have an issue. Let's suppose he gets me acquitted. Suppose I do a proffer and immunity and I'm done. 3 hours he spent for $200,000. Is that unreasonable? Some people might say yes. I don't think so. I think as lawyers you should make as much money as you possibly can, as long as they know going in what they're hiring you for. Sometimes people are not just hired for what they know, but their relationships. So, my 2 cents. Take it or leave it. Stay in the judgment bond. All right. There's a little quirk. You got to read the statute. You got to read the case law, and I have this. But generally, you can't stay a judgment unless you post a judgment bond. What is a judgment bond? A judgment bond is sufficient surety to ensure payment in the event the appeal is upheld, or to stay execution of discovery during the appellate process. Does it have to be, and I think the statute generally defers to 100% or 125% plus 2 years interest. However, that doesn't necessarily mean that that's what the judge is going to impose. A judge could impose less if that amount is unreasonable for that defendant. and I've had defendants in this catch-22. Judge, we want to stay discovery, we want to stop everything, and it's happened with Judge Rondolino, who's now our chief judge. I said, Judge, that's fine, but I want to see the books and records. Well, we don't want to give that to him, Judge. We're a small company. We make 30 grand a year. I go, Judge, the statute says that I get to look behind the curtain to see if they're telling me the truth, that they can't pay the full judgment bond. Person's claiming they can't pay 100 grand for the judgment because they don't have the financial ability to do so. It's inequitable for you to have to rely on that without engaging in some discovery so that you can show, Judge, they're right. Or no, Judge, this company makes $10 million a year, they can pay the judgment bond. All right? I went fast, it's 1 o'clock. I have cards, or get me your information. I will send you stuff. It will help you, and it will just assist you in any of this stuff. It's good stuff. All right?
Thank you.
Yeah.